Richard and Lee, here to talk to you about an issue in the case which is very important. It's derivative liability or vicarious liability. It's an issue that we talked about the other day, and I'm concerned, perhaps a bit troubled, that following our meeting last Thursday, that my point was not adequately addressed. So I'd like to address it again, just to make sure that you both understand. When it came time to the grand jury, Richard, you'll remember, Wright, Allison Wright stood before the grand jury, and every other word out of her mouth was Stetch and the law office of Ken Schwartz. So when she talked about Dos Ramos, for example, she talked about Dos Ramos dealing with the law office of Ken Schwartz and Stetch. When she talked about Adrian Freitas, when she talked about the banks, everybody dealt with Stetch and the law office of Ken Schwartz. Now, did she say it based upon any writing? No. Did she say it based upon me personally being present? No. She made this statement solely because Stetch was my employee. Stetch being there, according to Wright, was the same as me being there. Vicarious liability. When Stetch spoke, I spoke. When Stetch wrote, I wrote. When Stetch made notations on documents, when she notarized, when she witnessed, when she did it, I did it. But that's not the law in this state. Frankly, it's not the law in this country. Derivative liability or vicarious liability was addressed by the New York Court of Appeals, and in the 1930 Harvard Law Review article, both of which are set forth in the website in the section on the law in New York. And it says that vicarious or derivative liability does not apply in a criminal sense in general. What is vicarious liability? Just so we're both on the same page. It's liability for the acts of another solely because of a legal relationship. Perhaps one of the more common uses of the term would be in the employer-employee context. So, an employer is responsible for the acts of an employee if done within the context, within the scope of employment. If the employee frolics and detours outside the scope of employment, then no. But these are civil concepts. They are not criminal concepts. And if you look at People v. Byrne, which I hope you do, and you read the Harvard Law Review article from 1930, you'll see that vicarious liability only applies in a very limited sense in criminal cases. It applies in building department cases. It applies in the context of a corporation. That is, where you're holding a corporation responsible for the acts of an employee. It applies where a liquor license might be at stake. It does not apply in the case of felonies. It does not apply in the case of imprisonment. On the website in this section for the law in the state of New York or in this country, I have enclosed some cases from the 11th Circuit that stand for the proposition that in cases where there are substantial terms of imprisonment, or frankly any term of imprisonment, vicarious liability cannot apply. Now, Wright has done something which is totally unprecedented in this country, in this state, in New York, and it's contrary to People v. Byrne, so she's acted outside the law. She said that in the case of a B felony, I think that's what I'm charged with, a B felony, that vicarious liability applies. Why? Because the law office of Ken Schwartz, according to Wright, is me. Now, People v. Byrne says that vicarious liability in a criminal sense doesn't apply when we're talking about a natural person. I, at last count, am a natural person. Stetch did not have authority to represent me in a criminal sense. Maybe in a civil sense she did, but not in a criminal sense. So Stetch's acts were not my acts. Therefore, when Wright paraded before the grand jury and she constantly used the term Stetch and the law office of Ken Schwartz, no. That was contrary to People v. Byrne. She was making up her own law. Put another way, it was unlawful. Imagine that. Wright was misleading the grand jury. Now, did she give instructions on the fact that she misled the grand jury? Probably not. She probably didn't bother telling the grand jury that vicarious liability doesn't apply. So when she constantly used the words Stetch and the law office of Ken Schwartz, that was improper. She should not have done that because she created the distinct impression that when Stetch spoke, I spoke. When Stetch attended these paper signings, events she called closings, that I attended. Why? Because she was my representative. And in fact, that doesn't apply. Now, the law office of Ken Schwartz is not a legal entity. Richard, when you and I spoke the other day, you thought it was. It's not. The law office of Ken Schwartz is a notation on my letterhead only. Look at my payroll tax returns. It's Kenneth Schwartz. Look at the legal relationship. I am a person. I am a natural person. The only way that I can change that is by forming a corporation. But I was not a PC back in 2008, 2009, 2010 when these events occurred. So by no stretch of the imagination was I anything but a natural person. And since the law office of Ken Schwartz does not exist separate and apart from me, the only way she could use that phrase is by referring to me. And the impression she wanted to create before the grand jury, indeed the impression she did create, is that anytime Stetch spoke, I spoke. Stetch acted, I acted. Stetch and the law office of Kenneth B. Schwartz. All of her questions, that's how they were phrased. Now, when this case goes to trial, I promise you that she will be appearing before the jury, and she will use the term Stetch and the law office of Ken Schwartz. When she questions Das Ramos, when she questions Liebert, when she questions Bassi, Prasad, anybody else involved in this case, she'll say, "Ma'am, you met with Stetch and the law office of Ken Schwartz. You need to stand up, object, and don't let her do it, because I will not be in a position, or should not be in a position, where I stand and object. But your knee-jerk reaction, Richard and Lee, must be to get on your feet, stand, object, and vigorously explain to the jury and the judge. Vicarious liability does not apply in the state of New York. It just doesn't." Wright should know better, and she probably does, but her and her boss, Greg, are looking to break the law in order to hold me accountable for the acts of Stetch. So the purpose of this discussion is to make sure that you both understand vicarious liability, vicarious liability, vicarious liability. Perhaps the single most important part of this case does not apply in the state of New York. And if Wright should appear before the jury and she tries to use the phrase Stetch and the law office of Kenneth B. Schwartz, it ain't so, because I am a natural person. Vicarious liability doesn't apply. So when Stetch appeared on her own. When Stetch notarized, Stetch did it on her own. When Stetch made a phone call, Stetch did it on her own. After she was fired, when she appeared at Amanda Bardalis' house to deliver a closing statement or whatever the heck she was doing, according to the grand jury testimony of Amanda Bardalis, she did it on her own. It wasn't me. I am not part of Stetch. Stetch is not part of me. If it's not my acts, if it's not my phrases, if it's not my handwriting, then it's not me. So, derivative liability, vicarious liability, People v. Byrne, 1930 Law Review article. Please, please, please read it and understand it. Thank you, gentlemen.